Hi there, and welcome to sydneydrinkdriving.com.au. Hi guys, my name is Josh Balmain. I'm from sydneydrinkdriving.com.au. Today I just want to update you on a matter that I had a couple of weeks ago at Balmain Local Court. This was a matter where my client was charged with a low-range PCA or DUI offence. The blood alcohol reading was 0.069. So it was more at the higher end of the low-range category. Basically, my client was a father of three young children. He had quite a high-powered job as a general manager of a large company. He was the sole income earner for his three children and his wife, and he was getting ready to take off overseas to work in the UK on secondment for around 12 months. And unfortunately, he wasn't able to take the time out, or time did not permit him to take 6 weeks off to complete the traffic offenders program. He was desperate to get a Section 10 in order to avoid a criminal conviction, since he does spend a lot of time travelling overseas and around the world, both for work and for pleasure. The incident basically occurred when my client had gone over to a friend's place to have an early dinner. A rather emergent type of situation occurred while he was at his friend's place, when he and his friend heard some screams coming from the next door neighbour. They looked out. The next door neighbour had fallen over and broken his arm. My client and his friend went to the aid of this fellow and assisted him, called the ambulance, and waited till the ambulance came to take his neighbour away to hospital. Now, this was quite a stressful situation that my client was just thrown in on this night. And afterwards he went back to his friend's place. They had their dinner, and my client did consume 3 drinks in the space of an hour and a half. And certainly he did not go there with the plan of drinking as many drinks as he did, and certainly not in the space of an hour and a half. But due to the situation that he was thrown into with the neighbour injuring himself, and the stress and anxiety that followed from that event, my client wasn't thinking as clearly as he usually would, and he drank these 3 drinks in quick succession over approximately 90 minutes. He then got into the car after dinner to drive home, didn't get far down the street, was pulled in for a random breath test, and blew in the low range category. And obviously we know the end blood alcohol reading was 0.069. So these were mitigating issues which I presented to the court. I was able to back up my submissions in relation to the emergency situation that my client's friend's neighbour was in by tendering medical documents to the court, just to show that this fellow did actually break his arm on the date, the same date that my client was charged, and around the same time. And I also had the injured person to write a statement confirming that my client had been there on the night and assisted him while he was injured. Basically what I wanted to do is I wanted to present to the court this evidence and these submissions to show that my client wasn't thinking with a whole lot of clarity due to this situation. And I also then wanted to look at my client's traffic history and show the court that this incident was very uncharacteristic of him. It was his first drink driving offence, and it was his first major traffic offence. And of course he had no criminal convictions on his history. So I wanted the court to see that it was this extenuating features that was involved in this situation on the night that my client was caught, that led to my client not thinking as clearly as he could have and making a decision which was obviously clouded to drink those drinks and then get into the car. And obviously really pushed to the court that it was very much out of my client's character to do what he did. After making these submissions to the court, I also showed the court that my client didn't have a long distance to drive. I was able to print out a map of where my client had been drinking, where he was pulled over and where his house was. And the intended route of his driving to his place was only a few kilometres away. So what this does is that it, whilst no drink driving should ever be considered trivial by any means, but I was able to show the court that the intended route was short and there was a reduced risk of injury to others on the road. And especially given the time of night, there was minimal traffic on the road. I also pointed to the police fact sheet, who did actually make mention that my client was very cooperative with police and that he did not appear to be affected by the alcohol that he had consumed. After making these submissions, the magistrate at Balmain Local Court was insistent that my client went along and complete a traffic offenders program, especially if he was really pushing hard to get a Section 10 dismissal or Section 10 good behaviour bond, where no conviction would be recorded for this offence. And as I've mentioned before, unfortunately, the situation my client was in, the next day after the court appearance, he was flying out to the UK with his family to start a new role in the UK. And taking 6 weeks off was just, it wasn't going to work for him, delaying that trip for 6 weeks to complete the traffic offenders program. So the magistrate suggested that I go away, I speak to my client, see if I could make any arrangements for him to delay the trip, stay here, do the traffic offender program, and then come back before the court after a short stay of the matter and explain to the court if this was possible. I stood the matter in the list. I went outside with my client. I discussed with him if there was absolutely any way that he could delay the trip. He said that it was plans that had been in place for quite some time. Tickets had been paid for, accommodation had been organised over in the UK, and it was just not something that he was able to put his family through in sending them over and then him going over at a later time. It was just impractical. So I had to go back before the magistrate at Balmain Local Court and explain that it was just impractical for my client to do the traffic offender program. But in saying that, I then reiterated the strong points that I had presented to the court. And those were the fact that there was an emergency that my client was involved in. He acted very uncharacteristically on the night, and certainly if you have a look at his traffic history, there was no sort of other indications that this was a behaviour that he had done in the past. He had a very clean record, and certainly the certainly the character references spoke highly of him. And I also pushed the fact that he was a sole income earner for his family. They were going to the UK, and any sort of conviction recorded on his history may hinder his ability to travel to certain countries in the future. There was a fair bit of debate back and forth between myself and the magistrate, asking spitfiring questions at me about my client's situation, what happened on the night, and various other queries that she had in relation to my client's matter. I was at the brink of persuading her to issue a Section 10, a good behaviour bond, for my client. The magistrate then duly asked the prosecutor if the prosecutor had any objections to issuing a Section 10. And then this started a whole new debate between myself and the prosecutor, because the prosecutor got up and had quite a lot to say. She went on for about 5 minutes saying, submitting why my client should not be given the benefit of a Section 10 if he had not completed the traffic offenders program. I was then able to give oral reply to the prosecutor's submissions, and we did go back and forth for another 5 to 10 minutes, so it was quite a drawn out a matter before the magistrate. But at the end of the day, the magistrate was of the view that this was a one-off type of incident, despite the fact that the blood alcohol reading at 0.069 was at the higher end. She did take on board my submissions and obviously the evidence that was presented to the court, and did turn around and give my client a Section 10, albeit with quite a lengthy good behaviour bond of 2 years, which is the maximum period of a good behaviour bond that she could have given my client. But at the end of the day, he was not convicted, he was not fined, he did not lose his licence, and ultimately we got the best result possible for my client given the situation. It was probably one of the hardest fought Section 10s that I have got in the local court, due to the fact that the magistrate wanted us, or my client, to go and do the traffic offender program, and that was just impractical. And then the raft of submissions that came from the prosecutor to not issue my client with a Section 10 were quite strong. So not only did I have to provide oral submissions to the magistrate, but I also had to provide lengthy debate back and forth between the prosecutor and myself. And I was very thankful, and of course my client was very thankful that we were successful in persuading the magistrate to issue a Section 10. So guys, this is just another case of a drink driving matter that has appeared in the local court in New South Wales. Of course, we appear in all local courts around Sydney for all drink driving and alcohol related traffic matters. Certainly, if you have been charged with one of these offences and would like to speak to someone about your situation and your offence, please feel free to give me a call, Josh Balmain, on 02 9283 8622. I'm happy to have a free first telephone consultation with you to discuss your situation, the options you may have, and also to explain to you what we can do for you in representing you in your local court drink driving matter. First step you might want to take is actually going along and visiting our website, which is sydneydrinkdriving.com.au. There is a whole raft of information there on drink driving laws, offences, results, blog posts, videos. There's a whole heap of information surrounding drink driving cases and how we handle them, and certainly that would be a good first port of call for you to take to get a better understanding of the situation that you may be in. And certainly after that, as I've mentioned, give me a call. I'm happy to have a chat with you on 02 9283 8622. Thanks guys.